Good morning, everyone. My name is Rosalind Dixon. I'm the Director of the Gilbert and Tobin Centre of Public Law. It's my great pleasure to welcome you to this seminar today. Before we begin, I'd like to begin by acknowledging that we're all coming to this meeting from diverse First Nations land, and even our guest, of course, in Canada is doing the same. I acknowledge that I'm coming here from Bidjigal land and pay respect to elders past, present, emerging, and to all Aboriginal Torres Strait Islander colleagues joining us today. And I want to lend my voice to the calls of First Nations people at Uluru for structural change to the Constitution to entrench their voice in our constitutional system. It's my great delight today to introduce three eminent administrative and public law scholars. Our guest from Canada is Professor Mark Walters, who's Dean and Professor of Law at Queen's University and will be known to many of you. And today we're going to talk about his very important new book, V Dicey and the Common Law Constitutional Tradition, A Legal Turn of Mind. There have been many reviews, Mark, of this book around the world. Some absolutely love it, some don't. But a mark of a great book is the conversation it sparks. And by that test, you have more than succeeded in generating a vibrant and important discussion about the rule of law. And it's a wonderful treat for us to have you here today to engage with us in Sydney and around the state and country on this issue. We have two very esteemed colleagues joining us from Melbourne/UNSW, my colleague, Associate Professor Janina Boughey, who's the Director of the Administrative Justice Project and an ARC DECRA Fellow, and whose work has previously been focused on a Canadian-Australian comparison on administrative justice and human rights, and is eminently well qualified to comment on this book on almost every level. She's also joined by Dr Lynsey Blayden, who's a postdoctoral fellow at two of Australia's great law schools, Melbourne Law School and UNSW. We're delighted that Lynsey's back with us in Sydney, and that she is, developing expertise around a whole different set of questions on social, liberal, and progressive understandings of positive constitutionalism and how they intersect with the rule of law, and will no doubt bring that into dialogue with Mark's book today. So, Mark, thank you very much for joining us. We're going to hear from you for 5 to 10 minutes about what the book says for those who haven't yet had a chance to read it. We'll hear from Nina, Lynsey, we'll give you a right of response, and then we'll be taking questions from the floor. Those of you who've been to one of our seminars before will know that you're welcome to post your question in the chat, and I'll be happy to then feed it back to Mark. Or if you'd like to ask it in person, please just raise your virtual or actual hand as our discussion from the panel concludes. We definitely will be leaving some questions, time for questions toward the conclusion of the seminar, and we welcome any questions along the way in the chat. So without further ado, Mark, thank you so much for joining us, and it's a real pleasure to be able to celebrate this great book.
Thank you so much, Ross, for that very kind introduction. I can't tell you what an honor it is to be invited to this this forum, and thank you for your kind words about the book. You never know how things are going to be received, and as you say, the mere fact people are reading, and even if they disagree, is a good sign in a way. Just to have people reading is important. So as you are located in traditional territories of Indigenous peoples, so we are here as well. Queen's University is in Kingston, Ontario, which for those of you who don't know the geography is just at the point where all of the waters of the Great Lakes flow into the St. Lawrence River, just at that point. And for centuries, a meeting place for diverse peoples, and we here acknowledge the importance of these territories to the Anishinaabe and Haudenosaunee peoples who are Indigenous to this territory. So I've been asked to give just a very brief overview of the book, for especially for those people who have not had a chance to read it, and many of you won't have. It is about Albert V Dicey. It's about the common law constitutional tradition. We can say that much due to the title. I guess what the book is really about is, I wanted to say common law constitutional tradition rather than British constitutional law, because I think the principles that Dicey develops in his work were and have been transferable and have been very significant and influential in all of those systems that follow a Westminster parliamentary / common law approach to governance and to law. That would include, of course, Australia and Canada and many other jurisdictions throughout the world. So it's that idea of a tradition that I wanted to focus on rather than substantive law. So I do a little bit in the beginning to explain what I think a tradition is. But it is, I think, an ongoing discourse that we can join and in conversation with people who've been participants in that tradition over time, with a view to drawing from the tradition a conception of law or constitutionalism that would be compelling for us. So that's really the objective of the book, is for me to engage, I guess, in a kind of a conversation with one of the leading scholars and writers in this tradition, Albert Van Dicey. The book that he's famous for in relation to constitutional law is Law of the Constitution. It was first published, by the way, Dicey lived between 1835 and 1922. And he was the Vinerian Professor of English Law at Oxford from 1882 to 1909, just to put him in his historical context for those of you who don't know. And his book that really is the subject of my book is Law of the Constitution, first published in 1885. The last edition during Dicey's lifetime was the 8th edition in 1915. So the life of the book and Dicey's life spanned a long time. And then the life of the book just keeps going after Dicey's death, and in many ways takes on a life of its own. So my book is a quasi-intellectual biography of Dicey, and this biographical approach is a kind of vehicle for exploring his work on constitutional law. And incidentally, some of his work in other areas, political writing and his writing in the conflict of laws, for example. And then that forms a vehicle for then exploring the common law constitutional tradition, as I call it. So in a way, the book is an odd or curious combination of genres in terms of scholarship. It's a bit legal history. It's certainly a bit legal biography, but I don't shy away from conceding that there is a normative argument or a set of arguments as well that are being developed in the book. And I suspect that may be one aspect of this approach that might attract criticism. The fact that I'm mixing these more historical and descriptive with normative aspects. And I guess the other possible, no doubt controversial approach is that I have challenged some of the orthodox views about how Dicey and his work is interpreted. Martin Laughlin has this wonderful phrase in one of his earlier books that Dicey is the high priest of constitutional orthodoxy, sort of a cold, austere, positivist, authoritarian writer or jurist in his approach to the Constitution, somebody who wanted to separate the treatment of the law of the Constitution from the politics, history, and morality of the Constitution. And not only that, somebody who was ideological in his approach and probably very nationalistic as well. He's famous for his critique of French administrative law in particular. And so part of the effort of the book is to at least put some of those attributes or characterizations of Dicey and his work into question and to suggest alternative readings, and with a view maybe to, or hopefully, to improving our own ability to interpret the constitutional tradition that still forms the background, I think, to understanding constitutions in places like Australia, Canada, and of course, the United Kingdom. So that's a kind of an overview. I think maybe that probably is sufficient for the moment. And I should probably turn the floor over to, I'm not sure who's next actually, but
Nina, thanks so much,
Nina.
Mark. That's terrific. Over to you, Nina.
Thanks, Ros and Mark. I would also like to start by acknowledging the traditional owners of the land that I'm joining from, the Ku-ring-gai people. So I became a big admirer of Professor Walter's work when I started my PhD over a decade ago, which compared aspects of Australian and Canadian administrative law. And I first started researching Canadian law and found it to be a total mystery. It made absolutely no sense to me because on the surface, at least, it looked very, very different to that in Australia. For example, what on earth happened to the concept of jurisdictional error and where did your grounds of review go? But I found that Professor Walter's writing provided the clearest explanation in a way that I've come to appreciate demands a very deep knowledge of the history of law, an understanding of how it's developed in other common law jurisdictions to allow for a truly useful comparison, as well as understanding of theory and doctrine. And that's something that Professor Walters brings to his work that makes it particularly illuminating. So when Professor Dixon suggested this seminar, I jumped at the opportunity to read and discuss this book. And although my expectations were very high, I certainly wasn't disappointed. This book is extraordinarily thorough, and as Professor Walters has explained, it reanalyzes Dicey's arguments and ideas and contextualizes them in the events that were occurring at the time, as well as through Dicey's other writings, including a lot of his private correspondence and the writings of his contemporaries, of which he was aware. So I think the clear purpose to me of this book and re-examination was to defend Dicey against some of the common criticisms that, in Professor Walter's words, he was a cold and austere formalist who is dismissive of law's historical, social, and moral contexts, dimensions, and horizons. And by re-examining Dicey's work in this context and through this lens, Walter shows a level of nuance that I think is perhaps inevitably missing from the oversimplified story that has been constructed about Dicey's core arguments. And I say perhaps inevitably just because of the level of influence that he's had and the sort of almost mythologized position that his theory holds in public law circles. But from that analysis, I thought I'd just point to a few of the revelations, I guess, that I found particularly interesting, which were first, Dicey's commitment to substantive as well as procedural equality is one of the arguments that Walters makes. So Dicey's thin conception of the rule of law is typically viewed as the exemplar of a concern with procedural equality only. But Walter's re-examination of Dicey's writings beyond the law of the Constitution and re-examination of the passages of his book in that context reveal that Dicey, at least in some contexts, did seem to hold deeper views about equality. Another interesting and somewhat surprising revelation was Dicey's views on the evolution of the common law and how it interacts with also the interactions between judicial practice and public sentiment. Dicey's focus on parliamentary sovereignty is rightly, I think, interpreted as very much limiting the judicial function, as he's often cited favourably by conservative jurists and scholars in that vein. But this book shows, I think, that Dicey did not see the judicial role as nearly so limited, or the common law as so static and constrained as I think in modern times he's often taken to have done. And relatedly, in chapter 10, Walters explores Dicey's views on statutory interpretation and argues that Dicey may be read as supporting a stronger and perhaps less conservative view of the judicial role there as well, and a view which permits and perhaps even endorses reading statutes as consistent with fundamental rights and liberties where statutory language is not absolutely clear that those rights were intended to be abrogated. And Walters via Allen refers to Anna's Minnick as a case which may well have been quite consistent with the Diceyan conception of the relationship between parliamentary sovereignty and the rule of law. So I think in the context of the book, these arguments clearly work to undermine the modern image of Dicey as a villain of progressive legal thinking. But one thing I think is interesting examining this book or reading this book as an Australian scholar is that perspective of Dicey is not universal. Indeed, in Australia, the mythologized interpretation of Dicey remains very much orthodox, I think. So Sir Owen Dixon, who's been described as Australia's greatest jurist, was very much influenced by Dicey. And Australian administrative law, very recently in particular, has been described as more Diceyan than Dicey. And it's been criticised mostly by international scholars on precisely the same grounds as Dicey's work. So I'd suggest that perhaps in Australia, the perception of Dicey is more positive, and he's still seen as quite orthodox by at least a substantial section of the public law community. So I wonder whether then this rereading of Dicey in Australia might actually push some boundaries in a different direction and potentially ground a broader conception and less conservative view of the judicial role, one which supports the presumption that parliaments don't intend to abrogate fundamental rights in the absence of clear words, and perhaps even the extension of that presumption to new rights that have become fundamental to modern society. So I've just mentioned a few of the insights that I particularly found interesting there, but as I've mentioned, the book is meticulously researched, and so there were little gems throughout, some of which I can't not mention. For example, I was very heartened to learn that Dicey received a mere pass in property law, which I think means that there's still hope for me to become a somewhat serious and respected legal scholar, despite my dreadful mark in that subject. But another one was Dicey's writing to the Times, objecting to Australia's treatment of 2 Irish informers. There was a group responsible for, so the informers were in a group responsible for murdering 2 British politicians, and they informed on their colleagues and then sailed to Australia, but were not allowed to enter Victoria. The Victorian Premier said that although there was no law preventing their entry, public safety was the supreme law. And Dicey objected to this act of lawless executive power, which made me wonder how Dicey might have felt about the more recent treatment of a certain tennis player. But perhaps, back to some sort of more serious matters, perhaps I found the part of Dicey's work that is perhaps hardest to defend, even contextualised, are his arguments that the English constitution knows no such thing as administrative law, and also the mistakes he made in the earlier editions of his book about the French system. Walters acknowledges the serious limitations of Dicey's work in this area, particularly the inexplicable lack of attention to the prerogative writs, with the exception of habeas corpus, and his failure to acknowledge that the law had and was still developing to control executive action. And Walters notes that this omission is especially curious given Dicey's role as a barrister in many of the leading cases in which English administrative law was developing. So it's not just that Dicey failed to predict the development of administrative law in England, but failed to see or discuss the fact that it was already developing, which he well knew. He did eventually draw a link between the prerogative writs and English administrative law, but he refused to make the semantic concession of calling it administrative law and preferred governmental law instead. Criticisms of Dicey's parochial conception of the rule of law and argument that France's separate system of administrative tribunals are fundamentally contrary to the rule of law, I think I found also quite difficult to defend. Walters shows that Dicey's views on the French system changed over time. And by the final edition of his book, Dicey acknowledged that the French system even had some benefits over England's, that some government experienced amongst those adjudicating administrative law disputes, and even an independent tribunal system outside of the ordinary courts had some merit. And this was clearly a dramatic shift. And it's difficult to dispute that the shift was right today. So Walters argues that this is evidence that Dicey engaged in a genuine struggle to understand the basic ideal of legality, and that ultimately Dicey reached a position which viewed public law and legality as based around ideas of ordinary legal interpretation and the ordinary legal method. But I think the challenge is that Dicey took his time and remained very stubbornly attached to the idea that only the ordinary courts could uphold the rule of law in adjudicating government matters concerning government power for quite some time. And it seems possible that he simply finally changed his view in the face of overwhelming evidence that he was wrong about the French system. In any event, happily, Dicey's insistence that there is no such thing as administrative law has not survived, nor has his early view that there's no place within the rule of law for a system of tribunals or other bodies focused on delivering administrative justice. And I think many might see Dicey's opposition to bills of rights as equally indefensible, particularly in light of modern experience and evidence. Walters, drawing on Allen and Attia's analyses, argues that Dicey's argument was rather that statutory protection alone is insufficient to protect rights, as rights then become subject to the will of the legislature, but rather rights are best protected when woven into legal culture and the identity of the people. And I think this is no doubt right. But modern experience would seem to suggest, I think, that there's an important interaction that can occur between statutory rights protection and common law developments. For instance, developments in the substantive content of fairness in the UK have, I think, quite clearly been influenced by its Human Rights Act, as members of the UK Supreme Court have acknowledged, though in Dicey's defence, this is clearly not something he would have been in a position to see at the time. And it also, I think, seems consistent with Walter's rereading of Dicey, though I'd be very interested in your thoughts if that's right. So thank you to both Professor Walters and Professor Dixon for the opportunity to engage with this book. As I think it's clear, it's an important and very interesting and illuminating piece of scholarship.
Thanks so much, Nina, and for the close biographical reading of Dicey and his story, as well as for the provocation around what it means for contemporary public law. Over to you, Lynsey.
Thanks, Ros, and thanks, Mark and Nina. So I would like to acknowledge that before I begin that I'm speaking from Sydney, which is on the traditional land of the Gadigal people of the Eora Nation. Dicey is a giant who stands over the landscape of public law, British imperialism ensured that his presence is felt in many places around the world, including here in Australia. His legacy is profound, but also profoundly contested. In this splendid and incredibly rich book, Mark has challenged us to think once again about Dicey's most famous and influential work, Law of the Constitution, by seeking to place it in the context not only of Dicey's own thinking and beliefs, but also of his time. Mark notes that although the book was republished in multiple editions in Dicey's own lifetime, the core of its content remained the same as that contained in the very first, which was published in 1885. Mark goes on to note that Dicey stated of himself that he never ceased to be a mid-Victorian, and that the same might be said of his book. So to quote, Mark writes that Law of the Constitution will mean more for us today if we remember that it was written in 1885 and was not a book of some later date or a book detached from any time at all. I think this observation is correct, but what can we draw from it and why is it significant now? As we have heard, Mark has argued that Dicey should not be understood as a rule-bound positivist, but what he considers to be an interpretivist. On these points, he has already been very ably engaged by others, including Peter Kane, in an excellent review essay in the Modern Law Review. The book generated so many thoughts and questions for me while I was reading it that I don't think it's possible for me to do it any real justice here. So I just want to focus on one point in particular, and this is the question of how we use history when we're thinking about public law. I think that attempting to understand not only legal development, but also works of legal scholarship and other legal texts as the products of their time and place is an extremely valuable and necessary exercise. But to do so, I think, requires an engagement with history, which is, of course, a discipline with its own internal methods, which are different to those of law or philosophy. When legal scholars delve into the past, we must pay some regard to the constraints of this other discipline. But where are the boundaries between our disciplines and how well can we identify them? This is something that comes up for me in my own work on the Australian Constitution, and it's not something that I have a ready answer for yet. In a reflection upon attempts to make claims about those who lived in the past by attributing them with the sensibilities of the present, and also upon the differences between academic history, historical fiction, and myth creation, the Australian historian Inga Clendenin once wrote that while historians operated in a limited frame, what they could do was become increasingly knowledgeable about the contexts in which particular actions, including the writing of particular words, took place. She added that historians do this not by empathetic time leaps, which would condemn us to live forever sealed in our own narrow cultural and temporal world, but by reconstructing as delicately, as comprehensively, and as subtly as we are able, not only the material, but also the cultural settings in which people, once living, now dead, lived out their lives. I think Mark is right to say that Dicey's work was a product of its time and place, but I also think how we reconstruct or understand this time or place is something that is subject to its own field of debate, and that such a debate is perhaps one that would be conducted within parameters that are somewhat different to those of constitutional theory or public law. Something that both Mark and also Peter Kane in his review essay of this book remark upon, and I think comes out of Nina's remarks as well, is the strength of the critique that Dicey's treatment of administrative law has received over the decades. I'll come back to this shortly, but before I do, I want to note that Mark sorts the critiques of Dicey's formulation of the rule of law into three main categories. I only want to refer to one of these here, which is what Mark describes as the ideological critique, which perceives Dicey's rule of law, and I'm quoting once again from Mark here, as a peculiarly private law conception, as well as being a response to the notion that the rule of law is inconsistent with arbitrary or discretionary power. As Mark notes, this critique was first articulated clearly by Ivor Jennings, who is quoted by Mark as having written that Dicey's articulation of the rule of law was in part the subconscious reaction of Dicey's Whig mind against the intervention of the state in economic life, and further that the rule of law was nothing but a rule of action for Whigs that may be ignored by others. In the early chapters of the book, Mark gives an account of the way in which Whig politics had shaped Dicey's beliefs. He notes that the meaning of the word Whig depends upon context, adding that Bagehot described Whiggism as not a creed, but a character. To be a Whig at the relevant time meant that you were someone who was at once both liberal and conservative, and who believed that power must be disciplined by law. Jennings also wrote of Dicey's Whig influences, observing that a public lawyer, like a philosopher, is the child of his age. His ideas are affected not only by his upbringing, but also by the floating ideas of the time at which he writes. By 1885, the remnants of the Whigs, with whom Dicey sympathised, had joined the Conservative Party, which Jennings said at this point in history believed in parliamentary government, but not in what we would now think of as democracy. According to Jennings, the Whigs fought the expansion of the suffrage to the rural working class, which occurred in 1884 for as long as they could. Jennings also attributed the Whig belief in laissez-faire economic principles to Dicey. He considered that Dicey did not merely state legal rules that made up the Constitution, but that he sought to state constitutional principles, adding that in spite of all of his efforts, his subjective notions, the product of his time and circumstances, peeped out through his principles. Towards the conclusion of the book, Mark observes that the contention that the rule of law is for Whigs only is a deeply problematic one, noting that while Whig constitutionalism might have been said to be about protecting property interests, surely those who lack means are just as concerned with being protected from arbitrary action as the wealthy. I think this is incontrovertible, but I'm not sure that we have yet reached the point where we can jettison the idea that the rule of law can at times operate in ways that are more likely to benefit those with a measure of wealth and power. As I understand it, I'm not sure that it was ever the claim of Jennings or Robson, at least, as far as I can understand myself, that the executive should be able to act arbitrarily, but rather their concern was more about whether the ordinary law was the most appropriate way to constrain the modern state, or whether forms of constraint that were sensitive to the full range of its role and objectives were needed. As Peter Kane notes in his review of this book, what has emerged in England, and I think also in other common law countries, is an amalgam of common law and other legal restraints upon executive power. And this brings me back to my question about history. In the same chapter as he makes this point, Mark also observes that Dicey's book is Victorian, not in the Austinian sense, but in the Dickensian one. The word Dickensian, like the word Whig, perhaps evokes different ideas for different people, but it calls to my mind a society of debtors' prisons, old age penury, and child labour. It is well known that Dickens used his fiction as a vehicle for commentary on the many social abuses he saw in his time and also suffered from himself in his early life. Mark writes that there is no evidence to suggest that when Dicey wrote the law of the Constitution during the year 1884 to 1885, he was particularly concerned about the rise of the welfare state and therefore set out to construct a rule of law that would inhibit such a thing. But in this England of Dicey and Dickens, the kind of welfare state that would come to be built in some nations around the world following the Second World War must have seemed like a distant dream to the extent that its possibility was perceived at all. This, combined with his known Whig tendencies, leaves room, I think, for doubt as to how Dicey might have viewed a state that actively interfered in the lives of citizens for the promotion of their well-being, and did so through legislation enacted by a parliament elected not by a subset of society that held views congenial to other Whigs, but on the basis of universal suffrage. Whether Dicey intended it or not, his account of the supremacy of ordinary law has from time to time been a banner under which those opposed to a welfare or redistributive state have marshalled. I think the ideological critique issued by Jennings and the other early 20th century progressive lawyers was directed at what they perceived to be Dicey's own underlying ideologies and the ideological work to which his rule of law was put by others who came after him. Sometimes what the rule of law might obstruct is not necessarily arbitrary action, but collective action designed to support the common good, particularly where it has a redistributive element to it. No official action should be arbitrary or indeed unconstrained by law, but I think we need to remain aware of the ways in which the law might protect individual rights, but also leave the conditions which prevent the real fulfilment of them necessary for human flourishing undisturbed. This is a pressing problem for liberal constitutionalism. For many, including Jennings, but also later scholars such as Carol Harlow and Richard Rawlings, the absence of an account of the state and administrative law in the law of the Constitution is a direct result of Dicey's laissez-faire narrow or negative conception of the role of the state, and perhaps left us with a legacy identified by Nicholas Barber of a tendency to think of constitutionalism in largely negative terms. If my reading of your final chapter is correct, I think you see your argument about the way in which the interpretive approach you perceive in Dicey harmonises both parliamentary supremacy and the rule of law as one way to ensure that the right balance between individual liberty and the common good might be achieved. But to return to my history point, I'm just not sure whether Dicey's ideology would have shifted in the way that you suggest it might have done, especially given some of his later writing, for instance, in his introduction to his 8th edition, which I do acknowledge is something that you try to address in the book. The book is an ambitious project and one that I'm sure will provoke much thought and discussion. It is worthy of close reading and reflection because it touches upon so many questions and debates that are right at the heart of how we think about constitutions and constitutionalism. So thanks to Mark, Nina and Ros for the opportunity to take part in this conversation today.
Thanks so much, Lynsey. And I think, where you ended, which is the idea that maybe that, the synthesis that the book presents is more Walters than Dicey, and that actually, Mark, your own conception of public law is more attractive than the one that, Dicey would ever have been able to generate. I think it's very interesting. I have a book that's forthcoming on responsive judicial review that tries to construct a neo-Elian account. And for the people familiar with the US, John Hart Ely is obviously a much less significant figure than Dicey, but a very influential American constitutional theorist. And one of the reactions to the book is, this is Dixon, not Ely, and there's no real connection. And so I do think there's a broader question about what are the stakes when we try and render a normatively attractive vision of public law, of connecting it to prior thinkers who may have some resemblance to our ideas and that can be, fitted into our schematic, but may actually be being stretched quite considerably by us as contemporary theorists, and what are the pros and cons of connecting our new ideas to those old traditions in ways that involve that stretching. Forgive me, Lynsey, if that's not a fair reading of your comment, but I think it is, and I think you're very right to suggest how much this is Dicey and how much is it Walters, and that in itself is a great provocation. So back to you, Mark, for a response before we turn it over to our audience. But again, if you are in the audience and like to ask a question, please feel free to let us know now by posting in the chat or later, as the case may be. Thank you very much, Nina and Lynsey. Back to you, Mark.
Thanks very much, Ross, and thank you both, Nina and Lynsey, for such a careful reading of the book and incisive and I think accurate concerns about some parts of the book. And so I'll do my best to I've taken notes. If I've missed anything, you'll correct me or help me in terms of identifying the points that you've made. One point that I do want to make, though, just as an acknowledgement, and I do this in the I guess in the introduction, is the work of Richard Cosgrove. So he wrote a very important biography of Dicey in 1980, and so although my research involved a lot of archival research and a lot of time as a result. Without the guide that Cosgrove gave, it would have been really impossible to write this book. So I'm really indebted to him. Then it occurs to me as I'm listening to perspectives from Australia, the Australian connection is really an important one too, because Dicey always said, at least privately, and actually sometimes in his writing, that he didn't think he was ever articulating any original or new ideas. He was synthesizing ideas, drawing out ideas that anybody could have seen had they bothered to, extract the general points from the mass of data that consists of the law. But I think he was influenced by William Hearn, the first Dean of Law at the University of Melbourne, whose book, written in 1867, it is one of those books that is full of detail and basically touches on all of the basic principles that Dicey explores, but it's just buried. You know, all of those great ideas or not so great ideas are buried in a barrage of information. And Dicey had this unique ability to present ideas in an accessible fashion that that at one level seemed to simplify everything neatly, yet at the same time derived from a fairly complex set of phenomena, constitutional, both political and legal. Now, back to Janina's points. I think really it's a point that overlaps with some of the points that Lynsey makes, and that is, as Ross says, whether this is more Walters or Dicey, or, you know, Trevor Allen plays a role too in my thinking, although we approach Dicey in a somewhat different way. I should say, I don't know if any people here know the work of David Sugarman, who's a legal historian a wonderful legal historian in Britain, and he had written quite a bit on Dicey in the 1980s, and he read some drafts of my work, and I met with him, and he basically said, this is interesting, this is good, but you have to tone it down a bit. It's just, you're pushing it too far. You're pushing your own argument too far. And if you just brought it back or dialed it back a little, it would be more persuasive and effective. And I said to him, I see what you mean, and I'm going to try to do that in the final book. And when I came to writing, especially the last parts of the book, I think I forgot his advice, and I just went for it. But in terms of that critique that I think both of you have identified, that the history part, the normative part, my thought was that I could have it both ways. I don't know if I can, but I thought I could, and in the following way, that I would do my best to present the story of Dicey and his book faithfully to the facts, and yes, the reconstruction of the past in the present always will involve a certain interpretive effort and decisions, judgments, what to stress and what not to stress. And this is really more about a theory of history and writing history than a theory of law. But I thought if I could do my best to be faithful to the history, then it would become obvious to the reader when I was departing from, when I was shifting from wearing the hat of a historian or a biographer and putting on the hat of a critic, involved in a critical examination of some of his work. And it's not as if I could have maybe written two parts, you know, the historical part and the normative part, but instead they're threaded together throughout the book. And that is going to cause difficulties for a lot of readers, I think. Having said that, I had hoped that it would be clear when the shifts were made, and it probably isn't. And maybe I've even tricked myself into thinking that I've been clear when I haven't. But I wouldn't deny that there's an interpretation that is presentist involved in this book at some level. And that, as I said in my opening remarks, this is part of how I view working within a tradition. So taking seriously the previous participants in that tradition, but engaging with them at the same time in a manner that might show the tradition in a different light. So I'm just now going back to my notes from Nina's comments. I think your concern about administrative law is my concern too. I had hoped, naively, that perhaps in somewhere in the archives, in the private correspondence, somewhere we could find some kind of explanation for Dicey's mysterious failure to really account for something that was right in front of his face as a lawyer, not to mention as a scholar, which is the existence of a particular law of administration in the common law tradition, in English law, and yet there isn't. I don't think I drew this connection in the book explicitly, but part of the reason why I felt it was helpful to look at Dicey the person was to explore some of his peculiarities as an individual. Dicey the person was quite a quirky individual. He had a physical disability, which was fairly serious, although not really explained in a lot of detail in any of the contemporary writings, either public or private. He, as one observer noted, had a very little control over his physical movements. He was prone to falling down. He could not write. He had to dictate everything. And I think that as Sir Frederick Pollock called them, his colleague at Oxford, the oddities of AVD were pronounced and understood, and all of his friends seemed almost to accept them without mention. And just from time to time, you get this acknowledgement of his oddities, and it's not just a physical thing. I think it's hard to know, but he certainly had a personality which was quite distinctive. I'm not a medical expert, and I wouldn't even try to diagnose his personality traits, but there is a kind of extreme focus on really an extreme focus on certain things. And how does this relate to his inability to depart from a point that he had arrived at so emphatically, which is administrative law is French and it's not consistent with the rule of law. And we don't have anything like that in England. There's no administrative law in England. And once he had arrived at that conclusion, it seemed almost impossible for him to imagine how to backtrack. And whether he even wanted to, I don't know. But I think something about his personality there is informative and interesting. And one could say his, and neither of you mentioned his obsession really with Ireland, but he became absolutely obsessed with the question of Ireland. And this diverted so much time from what might otherwise have been quite productive legal work. And he could never let go. He, until his last few days, he was saying he was so sad about Ireland and the loss of Ireland to the British Empire. So he's a peculiar character, and understanding those peculiarities, so this is where the biographical part might help shape the understanding of his legal work, is helpful, though I appreciate that I'm kind of on thin ice here. I'm making a lot of speculative assumptions that have to be acknowledged as quite skeptical. But Nina, you're quite right. It is rather hard to understand why he would approach administrative law in the way he did, and how he couldn't have seen in the very cases that he was arguing so much rich potential for an examination of the kinds of legal issues that now we see, and quite frankly, from Ivor Jennings' day on, we've seen as so important to understanding the common law constitutional tradition. The importance of discretion, the importance of governmental expertise in certain areas, and the reality that modern government needs these kinds of decision-making powers, and yet this doesn't necessarily mean jettisoning the rule of law. It just opens up what is just an ongoing conversation about administration, executive action, and legality. So it's we can't take that book and read it today and find lots of helpful things to say about administrative law as a result, unfortunately. Nina also mentions there that the ordinary legal method is a dead end. Well, you didn't say dead end, but it doesn't really lend itself to a productive form of discussion about legality in a modern state. But of course, in the book, I've tried to say one reason why we might want to reconsider law of the Constitution is to reconsider that the claim that ordinary legal method might be a valuable idea, even in a day and age in which we all accept that decision-making can't and should not be made by ordinary judges in ordinary courts. That administrative decision-making of all kinds and the vast array of administrative decision-making is quite remarkable, is inevitable and a good thing in the right circumstances. And so what is it that I see in ordinary legal method and therefore in Dicey? What is it that can be drawn from that? That's a good question. And very quickly, I would say that in his work in the very first years of the 20th century, when he was persuaded to revisit his approach to French administrative law and re-examine it, Dicey, I think, as you say, began to acknowledge, hey, there's something valuable here, arguably. First of all, it's not despotism of the kind that I originally said. The Conseil d'État in France actually is developing a rigorous form of law. Why is it law? And here I think it's very interesting. I've made the argument that Dicey is not an Austinian positivist. He may be a positivist of some kind, but John Austin really isn't the guiding light for him. Austin would say, well, law is just whatever the sovereign commands. Looking at the jurisprudence of the Conseil d'État, Dicey says it's law because they treat legal disputes in a legal way. And by legal way, he means, and it's the subtitle of the book, they have adopted a legal turn of mind. What is that? It's to approach a dispute as if the body of decisions that has accumulated over time provides answers, and we can turn to it. And even though the answers will not be explicit, we can draw from the body of jurisprudence appropriate responses that treat seriously the idea that people may have rights prior to the decision in question. And the Conseil d'État is approaching legal problems in that unique legal way. What one could say, he probably would say, it's beginning to look like a common law court. And therefore they are, their decisions are approximating law or beginning to look like law. That's not just discretion, it's not ad hoc decision-making. And they are assuming that the answers that they give must be consistent and coherent with the principles that underlie the body of decisions already made. And this is then, of course, leads into the question of Dicey as the proto-Dworkinian, which is a controversial claim. And I hope I've been careful about making that claim. But the essence of what I'm suggesting is maybe this is just ordinary legal method. And it doesn't matter what the label on the door is outside of the tribunal, administrative, common law. At some level, if we are to respect the rule of law, something like an ordinary legal method is going to be important. Otherwise, what is the law that is supposed to rule? I know that's a controversial claim in an era of legal pluralism, and I should say that my other branch of research is focused on Indigenous peoples and Aboriginal rights. And many people say, are you really consistent as a scholar in terms of your concern about pluralism and, on the one hand, legal pluralism when it comes to Indigenous people within Canada, at least, and this obsession with ordinary legal method and unity, which seems to flow from it? And I'm not, maybe I'm a little schizophrenic, but I don't think so. I think there are ways of thinking through these two lines of thought.
One of your points was that Dicey may have been too consistent and not been flexible in ways that you're seeking to reintroduce a flexibility in his thinking. I don't mean to cut you off, Mark, but I really want to give people a chance to ask just one or two questions, if I may.
Absolutely, yes.
So please let us know. We've only got a few minutes left, but if you'd like to ask a question, can you raise a hand virtually or in person? Well, I may have been precipitous in cutting you off. John Pike has an interesting observation, which draws on Austin as well as Dicey. Can you see that comment and question in the chat, Mark? Before you respond, is there anyone else who wants to identify themselves? Go ahead, Mark, if you wanted to comment on John Pike's question.
I'm just, it's a long statement.
It's a long one, it's complicated. You may have to take it on notice.
I will, but but I think that you're referring to an important point, which you have law of the Constitution. It has a sort of an objective as a book, and law and opinion in England seems to be, in some respects, a different kind of book altogether, and that's fair to say. And it is interesting, I think, for the reasons that you identify, this long, it's a huge book, but largely about the shifts from different kinds of styles of thinking about law and public opinion, and the rise of collectivism, which is clear. Like both of my commentators today are right in saying he was ideologically opposed to that kind of approach to the state. But I think there's a lot to unpack in that statement that you've made, or the question that you've made.
Indeed, and the the intriguing biographical part, the history, the theory, all such rich provocations. I think we probably are, coming to the end. I want to thank everyone for their, participation by joining today and having such an interest in the seminar and Mark's book. And I know there are many people who can't be here right now who are looking forward to listening to the recording. Thank you so much, Nina and Lynsey. Lynsey and Nina, for your very insightful and very detailed comments and engagement with the book. They're really wonderful responses. And Mark, for giving up your time and being with us here today. We really are delighted to have the opportunity to celebrate what is a really important and thought-provoking book, and to have you join us in Sydney. So thank you all very much for a great discussion. We look forward to seeing you at our next upcoming book series, which is in just a few weeks. And thanks all to the participants today. Thank you.
Thanks so much.